I think we can start. Okay. Good morning, good afternoon, good evening, depending on what part of the world you are joining us from today. And let me say a very warm welcome to you all for finding time within your busy schedule to join us for this webinar today. As part of the mandate of the AfAA, we shall from time to time bring experts in diverse fields to shed light on some complex areas of arbitration. It will be a continuous thing. And today, I will be looking at evaluation of damages in international commercial arbitration. Evaluation of damages in international commercial arbitration. The webinar will be for 1 hour. We'll have a conversation for 45 minutes. And thereafter, we'll take Q&A and comments for the remaining 15 minutes. So we aim to conclude the webinar by 6 p.m. The issue of damages in international commercial arbitration has recently become a recurring decimal ever since the UCO's award of $50 billion, which became the largest arbitration award in history. This is closely followed by the P&ID award, which was over $6 billion. I gather it's almost 10 billion now with interest and so on. And while I personally believe that the purpose of damages is to put a party in the position it would have been had the breach not occurred, and not to give an innocent party a windfall, without understanding the issues involved in evaluating damages and effectively communicating same to an arbitral tribunal, arbitrators will find it very, very difficult to render accurate and well-reasoned awards on damages. So by and large, you find that cases abound where issues of liability are easily resolved. But when it comes to the issue of damages or the quantum to be awarded, it is often misunderstood by a lot of tribunals. Today's webinar, therefore, seeks to provide answers to some of these questions that arise in damages in international commercial arbitration. How do we evaluate damages? What are the basic principles that are usually employed in calculating and quantifying damages? What are the various methods employed in calculating such? And what is the role of quantum or accounting expert witnesses in doing this? To provide answers and many more to these questions, today is Andrew Maclay. Andrew is the Managing Director at Secretariat International, based in London. He's an experienced expert accounting witness, specializing in international commercial investment arbitration in London, Paris, and Africa. He has worked as a forensic expert and accountant for over 24 years and has testified before ICSID, LCIA, and ICC arbitration tribunals. So without much ado, I'll go straight on to Andrew now and have his perspectives. Andrew, welcome.
Chief Bayo, thank you very much. I feel very flattered to be part of this this discussion this afternoon on a favorite subject of mine.
Okay. Let me ask you, Andrew, that ever since the decision of the English court was given in Hadley and Baxendale in 1854 on consequential damages from a breach of contract, where are we today exactly with regard to evaluating damages in international arbitration?
Well, Chief Bayo, I think you're dead right that Hadley and Baxendale is the foundation of contract law and damages. So I think from a damages point of view in respect of a breach of contract case, I think we're actually still in a similar position to Hadley and Baxendale. The basic principle of damages is, as you've said it yourself, it's to put a damaged party back in the position it would have been in if the contract had been honoured. So that still is the fundamental basis of damages. I think in terms of international arbitration, those of us who work in the ISDS investment treaty framework are also very much used to the Polish case of the Hotza factory case, which was all about the obligation of a breaching party to be restored. It was about restitution, basically, to be put back in the position that it would have been in before the wrongful act occurred. But in some ways, from a damages point of view, in terms of the calculations, it's a very similar calculation, whether we're looking at Hadley and Baxendale or whether we're looking in the international status at the Hotza factory case. So that's absolutely where we start.
Okay, let me ask you something. What are the basic principles usually employed in calculating or quantifying damages in international arbitration?
Okay, so
because
I mean,
we find that most times when tribunals sit, experts are brought from different places, all kinds of mumbo jumbo are thrown in, but which are really very complicated sometimes. But what are the basic principles employed?
I think the real place that we start off is what we call the but for minus the actual. So what you'll often hear us expert accountants talking about the but for and the actual. So what we're trying to say is that what would have happened had the contract been properly observed, and we call that the but for scenario. Or in an expropriation context, what would the oil refinery have made? What profits would it have made, or what profits would the copper mine have made if the intervening event hadn't occurred? And then you deduct from that the actual profits that the company has made. And we can often draw a picture that you have one line going up, what it would have been, and you have one line going much lower, what the actual is. And sometimes we can illustrate the loss as being the difference between the two lines. So the but for minus the actual is the fundamental starting point. And then we move on to things like the challenge for us usually is to estimate what would have happened in the but for scenario. And in that scenario, sometimes arbitrators expect the quantum expert to be a bit of a prophet of the future, to know exactly what would have happened in the future. We can only work with the client on the basis of what we think would have happened, what its own projections said would have happened, or what the industry would have said would have happened, what was going on in the country. So we look at all those trends as to what would have happened, and then we compare that to what did happen, and we try to make sure that the difference is only based on the things to do with the event causing the damage. So if, for example, there was an explosion at a plant, what we're looking at is the impact of that explosion, and we're trying to get rid of anything else that got in the way at the same time. I mean, one of the challenges has been, for example, with COVID, that's affected everybody in the whole world. So if we're looking at a breach of contract, we probably may need to exclude COVID unless the claim is related to the pandemic. So that's the basic structure, I think.
Now, okay, you mentioned about these lines. One thing I've found personally is that usually when some of these cases come up, Party A brings experts who come to testify that we use this particular method to calculate the damages. Party B brings their own expert. That one says we use this particular method. All kinds of methods coming. Can you give us an idea of the various methods employed in calculating damages?
Yes. So I mean, I'd start off by saying that in some ways I feel that as experts, we are meant to be servants of the tribunal. We're meant to be assisting the tribunal. And I sometimes feel it's bad that some of my colleagues as experts come with extreme cases. So, you have probably seen, you see claimant cases where the claimant comes with a claim of, $100 million. And it may not have an awful lot of basis. And then the respondent comes back and says, no, it's zero. And then you slowly get a bit closer together. I do feel that as expert witnesses, we have a responsibility to be honest and independent in our quantification. So that's my first comment, is that actually I feel that we're not called simply to be an advocate, simply to choose the highest possible number if we're the claimant's expert, or the lowest possible number if we're the respondent's expert. That's the wrong approach. But in terms of actual approaches, and we were talking earlier, I think there's a distinction between loss of profit cases and valuation cases. So if maybe I start off with the valuation cases, and the valuation cases occur particularly in the context of an expropriation, or when something has been completely lost. So you could have an oil refinery blowing up and there's nothing left of it. So that would be a total loss. Or you could have an expropriation whereby a state has stepped in and has changed the law, or has actually taken a copper plant away from the investor, and the investor has nothing left. So there are then 2 or 3 basic principles within valuation. And we use a thing called fair market value. So we're basically using fair market value, and we're saying what would the asset have been worth in a fair sale between an independent buyer and an independent seller. What would that value have been? And we look at it in the classic rules from the International Valuation Standards Council. We look at 3 particular methods. We either look at the income approach, which is often called DCF, or discounted cash flow. So in that one, we're looking at the life of the asset until it would have come to an end. So for example, if I was working on losses to do with an airport in Nigeria, which is one case I worked on, we'd be looking at the expected income from that airport over the entire life of the concession agreement. Say it's a 25-year concession agreement, you'd be calculating the cash flow each year for that 25 years, and then we discount that cash flow back to the current date to come up with a single number. So that's one approach. The second approach is what we call the...
Sorry, Andrew, before you go on to the other approaches, something just occurred to me now from what you just said. Now, if you use this method, how do you ensure, what I mean is you are seeing into the future. What are the variables? Yes, an airport example which you gave. Is the airport going to function 365 days a year? Are there going to be downtimes when something might happen? Would you put all those variables into consideration? Act of God, something,
Well,
yes.
the hand of God is a more interesting one, but the other variables definitely we'd include all of those variables in it. So we'd be looking at comparable airports in the region, say, and we'd be looking at how many days of the year they operate. In this case, it was in the Delta provinces of Nigeria. So we'd be looking at the weather. We'd be looking at the rainfall, and therefore we'd be looking at how many days of the year. Well, particularly when I was looking at the construction of this, there was a certain number of days in the year when you just cannot build anything in the Delta region of Nigeria because it's too wet. There's just too much rain coming down. It's impossible for any construction vehicles to operate. There's just too much mud. But that roughly from year to year. You don't know it completely nowadays with climate change, but roughly the number of days in the year that you will not be able to operate your construction machinery. And so roughly the number of days that you wouldn't be able to operate your your airport, for example. So you would use all the knowledge that you have. And particularly importantly here would be the projections that the company had already made. So, no investor is going to come into a country to start a new project without preparing a business plan. So it would have a business plan, and we would look at how reliable that business plan is, how realistic it is. And so, for example, the most important thing probably in any business plan is the revenue number. So for the revenue number, you would be looking at how much output there was going to be. Maybe I'll drop over into an oil well here. It's probably an easier scenario to give, but you would know, and here we'd work with other people. But say, if I was looking at an oil production platform, I would be looking at oil well experts who would be able to tell me roughly how much oil was expected from that oil well every year for the next 25 years until the concession ended. That's not my expertise. I don't know how much about oil. But then we'd be multiplying the oil by a price, and you have to multiply the oil by a particular price. What is the oil price in the future? We don't know. But you can look at things like what other experts say the oil price will be, or even more importantly, in terms of the oil price, you can look at the oil price markets, and the oil market has future prices. It has today's price, and then it also has the price for a barrel of oil in 5 years' time and in 10 years' time. And those prices are calculated by the market, by supply and demand. So we would tend to probably be using those prices to put into our model to get that model particularly strong. I mean, if I give another example of electricity. So I was working on an electricity project in Southeast Europe. And what was really important to us was to know whether there was a power purchase agreement in place. If there was a power purchase agreement with a price for the electricity, then I knew what the price was going to be for the next 20 years because it was fixed. If there was no power purchase agreement, and I worked in one of these in East Africa, there was no power purchase agreement, I really didn't know what the future price was going to be. It was very speculative. So I was looking at the strongest possible evidence of the revenue and the costs for the next goodness knows how many years. So say 25 years, you'd need to know that the best evidence that you can find and compare that to business plans, to other companies, and so on and so forth. And one really important thing also that's useful for validating the business plan is whether somebody independent has looked at it. So if a company has made a business plan and then gone out to the bank and borrowed $50 million, and the bank has actually given it $50 million, then that means that the bank also has confidence in the business plan. And that would give me great confidence. But if it was just somebody who'd made up I'm afraid I did one other case. I was given a single sheet of Excel with some numbers on it. And that was meant to justify a claim for $100 million. And I said, really, that just doesn't stack up. You need a strong business plan. But I think that's how we'd estimate and guess. But we are foretelling the future. We never know with certainty. And I could turn to you as a lawyer and say, what is the correct level of evidence? Because you have to, that the arbitration tribunal then has to decide how likely it is that my projections would actually have happened in the future, and whether there's sufficient evidence to make an award based on that level of sufficiency of evidence.
Okay, so from what you've said so far, you've kind of flowed from the discounted cash flow into a comparables approach, because you were talking of comparisons as well. Is that correct?
Well, no, I wasn't really. I was still talking about the discounted cash flow approach, because in the discounted cash flow approach, you're always looking, all of the cash flows that you estimate in the future are based upon something. So I wasn't dropping into the comparables approach. Okay. I was just looking at how we actually calculate the cash flows.
Can you shed some light on the comparables approach then?
Yeah. So the reality is that the discounted cash flow approach is probably the most commonly used in arbitrations. However, in real life, companies are often bought and sold on the comparables approach. So the comparables approach basically says you calculate what the profit of the company is in year one, and then you multiply that by the price earnings multiple of a comparable company. So say a company generates $10 million a year, and that its stock market value is $100 million a year, then you know that there's a multiple there of 10 times its profit. So what you'd be looking at in the comparables approach is you'd be looking for similar companies that are similar in as many ways as possible to the company you're looking at. And you'd say, what is their stock market value compared to their profit? What is that multiple? And then we'd be multiplying the profits of the company I'm looking at by that multiple. So that's half of the comparables approach. The other half of it, which is called comparable transactions, is that I'd also be looking at when a similar company had been sold in the past. So, for example, if I was looking at an aviation company, I would be looking at any transactions in the last, say, 5 years in that type of company and seeing what a real buyer had paid by way of multiple of that company's profits. So there are two aspects of the comparables approach. In reality, businessmen often buy and sell companies based upon a multiple. They and private equity companies particularly will have a multiple in mind, and they will then multiply that particular multiple by the profits of the company in order to work out how much to bid for it.
Okay. How about the sunk cost approach?
Yeah. So those first two approaches can be quite speculative and quite difficult to calculate, and can be based on lots of assumptions, and some of those assumptions are just not certain. So then there's the third approach, which is often used in arbitrations, and it's not technically a valuation approach, but it is a way of getting to an award. And this is basically to say that the claimant should be awarded the amount of money it's invested, simply the amount of money it's invested without including any particular profit on top of that. And typically this would be used in situations where you really cannot tell, you really don't know how much profit it's going to make in the future. So say, for example, you've got a company that's never started, and there are one or two of these examples of hotel companies. You have a plan on a piece of paper, it looks fine, it's going to generate 10 million profit, but nobody's ever started building it. There's no hole in the ground, there's no hotel, and you really don't know. So in those situations, often a tribunal will say, look, we just cannot tell what the future would have been, but we do think you've been wrong, and therefore you ought to at least be given back all the money that you've invested in the project. And Chief Bayo, you would know one of the things people look back at in arbitrations, particularly investment treaty ones, is a thing called the World Bank Guidelines of 1992. And in those guidelines, there was an emphasis that you could use DCF where you had a company with an existing plan, or where you have a company with an existing history of making profits, because then you would have confidence that it would make profits in the future. But if it's never actually made profits, however good the business plan is, you don't know. And therefore there's got to be a balance. And sometimes therefore the tribunal will choose to award the sunk cost rather than the DCF value.
Okay, thank you. Would you want to touch on loss of profit calculations and how to use them?
Yeah, so loss of profits it's slightly what I've been concentrating on up until now was calculating a valuation, and a valuation, say, is particularly used in an expropriation situation. But a loss of profits is particularly useful for a breach of contract. So say at the moment I've been working on a case in West Africa where an international investor had come into the country to carry out a particular service line, and then its contract was terminated before the end of its concession period. So it still had 2 years of concession period to run. So for that period, it had already been operating for 5 years. So we already knew that it could make profits. It'd be making profits, maybe a 30% gross profit margin on its turnover over that 5-year period. So what we could do there was to say, look, we know it makes 30% profit in the past, so it's likely to make roughly 30% in the future. We know what its revenue is going to be because that's set in the contract it's got with the government in this particular state. So you would say, we know the revenue, we know the gross profit margin, therefore we multiply the two together and we can calculate the profit it would have made over the remaining 2 years of the concession. There are always 1 or 2 adjustments you need to make. So, some things might have changed. There might have been might have needed to use more personnel or less personnel in that period. In this case, this did cover the COVID period. So I was also meant to be speculating how COVID had impacted this particular contract, which was difficult, and it gets a bit speculative, to be honest. And in many ways, I've left that one to the tribunal. I'm sorry if you've been the arbitrator, but I've said, look, I really don't know. There would have been probably some effect of COVID, but in this particular country, it's been less affected by COVID than, say, France or the UK. And so maybe it wouldn't have affected the contract at all. But so that's the loss of profits approach. Yeah, very important, particularly for breach of contract and commercial cases.
Yeah, this is where I have some problems personally. Okay, while doing that calculation, you are projecting to the future, right? Based on what you think that particular company's profit had been for the 3 years it was operating. Now take an oil and gas project.
Yeah.
The price of oil worldwide is very volatile. It could go down, it could go up. How do you put this into consideration? And talking about COVID, which you just said now, COVID came, nobody ever thought about COVID. It just came from the blues, shut the whole world down. So what do you do in that kind of situation?
Well, and yet you referred earlier to an act of God. And in some ways, I'm not saying that COVID is an act of God at all, but it has a similar impact in that it suddenly something came from out of the blue and you don't know, you never expected it. Nobody expected it. All the companies in the world were valued on a basis excluding COVID. And suddenly COVID came along and suddenly what happens? All of their profits, every single company in the world, not quite every company in the world, because some companies have actually benefited, admittedly, but an awful lot of companies, their profits went right down. And the valuations therefore also probably went down as well. And nobody expected it. And it's an example, really, I would say, of however much I try to foretell the future, I can never tell completely, which is another aspect I haven't mentioned, which is of the need to discount for risk, because you never know what the future is going to be. There's this logic that people will say $1 in your hand today is better than $1 in your hand in 2 years' time, simply because anything could happen in 2 years. Something like COVID could happen or whatever, and you might have much less value. So often when you're calculating losses, you do need to discount for risk to take account of the fact that today it's less valuable. But in terms of the oil price, I think one doesn't know what the oil price is going to be, and there may be 2 or 3 approaches to it. One is to listen to so-called experts, and even they don't know. But there are oil experts, and what are we going to do? We have to rely on somebody, and so all we can do is to rely on the analysts, the famous analysts who think they know best. That's one possibility. Another possibility, though, as I mentioned, is that if you know the price of oil for the next 10 years because it's quoted in the London market, on the London Oil Exchange, I can sell a barrel of oil today I can sell a barrel of oil that I get hold of in 5 years' time at a fixed price today. So when you know that, when you know the future price of something, and that would apply to oil, it doesn't apply to many things, but it would apply to oil, it would apply to copper, would apply to iron ore. You know what the price is going to be, and you can therefore always set off your risk by buying or selling in the futures market. So that's one thing you can do with oil in terms of getting it more realistic.
Okay. I've just noticed that we have so many questions already lined up. So I'll just put one more question to you so that we'll have time for Q&A and comments. Instead of 15 minutes we were trying to allot before. Now, the last question I want to ask you is that, what is the role of quantum and accounting expert witnesses in calculating damages in arbitration? What role do they play?
And it's a really important question. I think what I always say is we're part of the industry. We're part of the community of international arbitration. And I love being part of that community because the community is mainly lawyers. It's barristers, it's foreign lawyers, it's advocates, it's solicitors who are involved in international arbitration, acting for claimants and respondents. But because an awful lot of these cases, the claimant actually wants some money back, there's usually a need to employ an expert accountant as part of the team in order to calculate that money. If it sometimes comes as a surprise to lawyers to know that the claimant actually wants money at the end of it, rather than just a beautiful award that they can put on their wall and say, you know, we won this award and we were right. If there are numbers involved, we tend to get involved. And then the rules under all the various international frameworks, such as the IBA guidelines on evidence, are all about the expert quantum witness being independent to assist the tribunal. But so we're not like lawyers because we're not advocates, but we're part of the team that helps the tribunal come to its overall award at the end of the day. So I love it because I think it's a fascinating world that we're in of commercial investment treaty arbitration. There are so many interesting people. There are so many things cross-border. All the cases I always seem to do, all the cases I'm doing at the moment, are cross-border. They're always between one company in one country and another company, or else another state in a different place. Many of them are, at the moment, are African, but they're always cross-border, and therefore you always have all sorts of interesting things as part of it. I did mention, I wrote down one other thing in my thoughts about this, and one other thing I find really valuable, actually, and I love doing, is visiting the site. So it's always valuable to go and visit the site because you learn so much when you go and visit a company. When I went to visit a copper mine in Lubumbashi, I'd never been to Lubumbashi before, but just going there, you could see lots of issues that were part of my claim. So we'd been making up I've been making a claim because one particular supplier had been replaced by another supplier. But just by being on the site for 3 days and listening to people and watching, and I was driven all around the site, I was driven right down to the bottom of the copper mine, and I listened to what my driver said. You know, you're just listening to what's going on, and you learn so much about it. And that may seem odd that an accountant should be interested in that, but that all turns into my report. So when I'm writing a report about the replacement of one supplier by another supplier, I can take on board what people have said to me. Or at that copper mine, I could see, I don't think it's any great secret, but a year ago, there was vast quantities of cobalt just dumped outside because the cobalt price had fallen in China. And therefore, what this company and all the other companies were doing in that area was stockpiling the cobalt. They were just dumping it outside, not even in warehouses, and hoping that they would sell it before the rainy season came. But it was interesting to do that because it contextualized at me. It meant that I could realize, hang on, the cobalt price is not the same as it was a year ago. Therefore, in my calculations, I need to make sure that I'm not using last year's cobalt price, whereas today it's actually 30% lower than it was a year ago. So things like that are really important in terms of the role of an expert on on understanding the whole thing. We can't, sometimes people think accountants are just numbers, but we take what's there physically and we turn it into a number. I think we have to understand the company and the way it operates in order to calculate a quantum claim. That's what I'd say to that one. Does that answer that question? I can't remember.
Yeah, you have. But one thing that worries me is that you did mention that the expert owes the tribunal a duty to assist it. But what you find in real life is that he who pays the piper dictates the tune. Because you find experts who have been employed by a particular party pandering towards supporting the case of that particular party, even in the face of some unreasonable conclusions. So, what's your take on this?
Chief Bayo, you're completely right, and I think it also this is a sensitive issue because it depends on which part of the world you're in as well, and it depends on how experts are perceived by the courts or the arbitrators in that particular part of the world. We have a sort of system in England now, in the commercial court in England, where we have very strict rules about independence of experts. And if I give evidence as an expert accountant in the High Court, what I will find is when the judge gives his or her judgment, there's always a few paragraphs now in the award where they will go through each of the experts. They evaluate them. They go through it. They will say, Mr. Maclay was a good expert. He gave an honest opinion and he showed his client's weaknesses. And then they will say, Mr. X seemed to be completely and utterly sold on his own client's side. And they will say, he didn't even consider the witness statements of the other side at all in it. So we have a big risk in the High Court in London at the moment. We have a big risk to our reputation. If I act, and the judges are pretty smart in the High Court, they know what's going on. They know the system. They were all barristers previously, so they've seen they know what goes on, but they're pretty strict. If I then go over to the US, where I'm doing a case in the US, in some ways it's quite different. My report I've been writing in the US is much more hardline advocacy. It's sort of, instead of starting with an independent first line, it sort of says the client is right because, and it's just a different style of writing it. And then you get into Europe, and I remember one case I worked on years ago, one of my first cases, we were working with a French firm, and I was working with a top firm in London, and so they were in charge, and they said they wanted an independent banking expert on this case. And I remember talking to the partner in this law firm in Paris, and he said to me, but we don't have independent banking experts. The court will know that the expert is completely partisan, and it's not really even worth paying for an independent independent banking expert, because we know they're not independent. So it's a balance. And I think I would love a situation where all of my profession was genuinely independent. However, that isn't the case. And I think it's up to the arbitrators to realize the system and to evaluate whether the expert is giving an independent view or not. And a bit like a High Court judge in London, if the arbitrators can see that the expert is being partisan, then firstly, I was going to say they should mention it in their award, but they just don't usually do that because it's not the normal thing in arbitration awards. But they should be taken into account in their award, and they probably do, in terms of saying, this expert I really didn't like. I didn't think he was independent at all. But what that means is when you look at the model that he's produced, the panel is probably going to say, I don't really trust that model, or I don't trust certain things in that model, and I'm going to trust the model that the more independent person has produced. it's a very controversial area, and I'm not sure that's a complete answer to it, but we try to be independent and honest, and I think that gives the best results to our client, rather than simply coming up with a number that is really, really big and finding that we get shot down in tears when we're cross-examined by a clever advocate in the hearing.
Well, it's quite heartwarming that the risk of reputational damage is there too, to question an expert. Our time is fast spent. I thought we could conclude earlier before the Q&A, but it's already 45 minutes is gone. And we'll have lots of questions for you on Q&A. And also, I want to enjoin members of the audience that if you want to make a comment, you can press the hand emoji, and I will call you to make your comment as well. So we'll just go straight to the questions now so that we can take as many as we can before our time is up. I'll read the questions out and then you can answer them. This question, the first question is from Daniel Wilmot from London. And he said, thank you for this insightful discussion. But for assessment of damages referred to is often inevitably premised on certain assumptions. That might include an assumption as to usual industry performance or usual market value of the assets in question. How does an expert proceed in times such as COVID, where usual market assumptions, or for example, valuation ranges, may no longer apply due to the exceptional market conditions, and which assumptions might otherwise result in the innocent party actually receiving a windfall? Put another way, how do you value something when the market no longer knows the actual or fair market value? Over to you, Andrew.
Yeah, I think, thanks for the question, Daniel. Nice to hear you. I think it's a very good question. It's a very challenging question. All I'd say is maybe a few comments. One is that ultimately the question of the value is something that actually is for the panel to decide, for the tribunal to decide. And I'm not ducking the issue. I think all we as quantum experts can do is to do our best possible quantification and say, look, there are these risks there. But in a COVID situation, it might be that the tribunal says, we know there's a COVID risk here. We don't know what that is, but we're going to decide on the basis that there is that risk that we're not going to give the highest valuation. We're going to give a lower valuation to take account of risk. And there is a thing in London called loss of a chance, and that's not used very much in continental jurisdictions, but some high court judges in the TCC, for example, would apply a loss of a chance discount to a calculation. That's one possibility. Another one might simply be, if the thing has got so uncertain, that's when I'd go back to the sunk cost approach, that it may be that you really can't tell what the future is going to be, and therefore all that you can fairly compensate the claimant with is his sunk cost. So at least he has that. And the third thought I had was in terms of the windfall. I think your subconscious question, Daniel, may be this interesting question that's a hot topic at the moment of the use of hindsight, in that you'd say, if somebody has a claim that's based on a 2019 valuation date, you might well find that the value of the asset in 2019 before COVID was much, much higher than it is today. And the traditional breach of contract, Hadley and Baxendale, Chief Bayo, would be based upon the valuation on the date of the breach of contract. However, there are various principles now in both in international arbitration and in the English High Court of things like the Golden Victory case, where it's right and fair and equitable. Well, this may not, even in a breach of contract case, it may be right that one takes account of things that have happened after the valuation date. I know that's a very controversial area, and it's something that lawyers argue about a lot. But we would sometimes do two valuations, one on a what's called an ex ante basis, sort of on the valuation date back in 2019, and then another one on an ex post basis, taking account of things that have happened after the valuation date, and then we'll leave it to the lawyers and the tribunal to argue about whether you're allowed to use hindsight or not.
All right, thank you for that. The next question is from Professor Paul Igonije from Abuja, Nigeria. His question is, can an expert be really independent when all the bills are picked by the party who appointed the expert? So how do you ensure independence and impartiality? Well, I think that's the one I asked you earlier, which you had answered, about the issue of the piper, he who pays the piper, dictating the tune. So I think you've answered that, because you risk reputational damage, and then a tribunal can actually come down heavily on an expert who does that. So I think that has been answered. The next question is from Abubakar Fall from Dakar in Senegal. He says, what has been the evaluation method used by the tribunal in the P&ID versus Nigeria case?
Well, do you want me to answer that one, Chief Bayo, or do you want to do it yourself?
Well,
I'll answer for you.
I take the Fifth Amendment here. Well, in any event, the case is now in public domain. Yeah. I participated as an arbitrator in that case, so I don't want to say anything.
No. Let me answer it.
But,
the reason I'm quite keen to answer it, because when I speak to African audiences,
right,
this case always comes up. I remember I was speaking at the East African Arbitration Conference a year or two ago. The last time it was physically held, I think it must have been 2 years ago then. And I mentioned this at the end of my presentation, and the whole audience gave a round of applause, simply because I was raising the question about whether an award of $6 billion or $10 billion US was quite a large award in an African context. So, but the answer, Dr. Fall, quite clearly is the tribunal clearly just used a DCF approach in its evaluation. So what they did was they looked at the business plan. They proceeded on the assumption that $40 million had been invested in this project. I mean, that's now a question which the High Court in England is going to have to consider, because it may not have been invested. But on the assumption that $40 million had been invested, they looked at the business plan over the next, I can't remember, 25 years. And the business plan showed cash flow, positive cash, well, it showed negative cash flow in the first 3 years whilst the plant was built. So the plant was going to cost $500 million, I think, to build. And then it was going to generate profits over the next 25 years. So they simply calculate all those cash flows, discounted them back to the current date, and came up with an award of 6.7 billion. And it was completely logical. If you do the logical Hadley and Baxendale breach of contract, that the claim is entitled to what it would have made, that was the logic on which it made it. If you want to go further, as you probably know, Chief Bayo issued a dissenting opinion. So, and I mean, I can quote his dissenting opinion. His dissenting opinion, in simple terms, was that you shouldn't have calculated the loss of profits over a 25-year period, because the investor should have mitigated its loss. And actually, that's something we haven't talked about, the duty to mitigate. So on the basis of mitigation of loss, in the dissenting opinion, Chief Bayo said that you should basically consider 3 years loss of profits rather than 25 years. So that's a very simple answer, and Chief Bayo could no doubt expand on it. But I think that's, as long as I haven't said anything wrong, that's the answer to the question.
Thank you, Andrew. Thank you for that. I'll just leave it at that. The next question is from Professor Emilia Oyama from London. And the question is, why do tribunals not use the sunk cost method in cases where the investment has not been completed or operational?
Dr. Emilia, that's a very interesting question. I think to be honest, I think sometimes they probably should do. I think the answer actually, though, is about the level of certainty about what's going to happen in the future. If the tribunal as sufficient certainty. In England, it's called the balance of probabilities. In the US, it's often, I like the phrase reasonable certainty. If there is sufficient certainty about the future cash flows of the project, then you can say in a breach of contract situation, had the breach not occurred, the claimant would actually probably, more likely than not, have generated the profit that the DCF approach gives. So it's basically that. It's a question for the tribunal to evaluate the level of certainty. You can be reasonably certain even if something hasn't been built. Sometimes, there are sufficient oil wells in the world. If somebody can tell you how much oil is in the well, you can calculate what profit you expect from it, because hundreds and hundreds of oil wells have been exploited. If you've got something that's got a standard history, I was working on a waste to energy plant. People know how much it costs to build a waste to energy plant. They know how much profit you're going to get from one because lots have been built. So it's a question of whether there's sufficient certainty or not. If there isn't sufficient certainty, then I think you should be using sunk costs. But where there is sufficient certainty, you can use it. I mean, another case which I get worried about is the Al Khalifa versus Libya case recently, where the Court of Cassation in Egypt has upheld an enormous award again for nearly $1 billion for a hotel that was never built. It's got 83 years of DCF profits included in that award. I presume the tribunal and the Court of Cassation felt that there was sufficient certainty to make that award. That's all I can say. It's a balance. The real thing is, has the tribunal got sufficient certainty that the thing would have made profit in order to make a large award?
Thank you. The next question is from Juan Carlos Wu from Curtis in London. And the question is, what is the expert's opinion? What is the expert's opinion about the so-called modern DCF method that was used to calculate damages in the Thethian versus Pakistan case?
Well, Juan, that's a very good question as well, and not something I can really answer in 2 minutes because it's a very big subject. But the Thethian copper versus Pakistan case is another enormous award of $5.5 billion. I think the modern DCF approach, what we say as experts is there's nothing modern about it. It's just a variant of the DCF approach. What one should be doing in DCF is looking at the most likely cash flows over the future and then discounting that back at a discount rate. What the modern DCF approach does is it puts much more of the risks of the project into the cash flows. So sometimes on projects, the traditional DCF approach tends to say, this is what we think the profit's going to be over the next 25 years, and we discount it back at a discount rate that takes account of risk and takes account of country risk premium. The modern DCF approach said, we're going to put all those uncertainties in the cash flow and then discount it back at a certainty equivalent discount rate, which is much lower, i.e. a risk-free discount rate. Both methods could give the same answer. So there's nothing inherently wrong with the modern DCF approach. But there were one or two things in the Thethian copper versus Pakistan case that I find slightly worrying. One of those is they also used a thing called a Monte Carlo simulation to project the future. So instead of projecting the future, they had 1.2 million different permutations of profit that could be generated by the project. They put the 1.2 million into a big computer model called a Monte Carlo simulation, and they generated an answer of $10 billion, which the tribunal then halved, basically get to $5 billion. But what worries me is that 46% of those simulations actually showed that the project would have made a loss. And it worries me that whether you take the midpoint, which came to ultimately $5 billion, or whether you need to consider the risk that actually 46% of those 1.2 million simulations would actually have resulted in a loss for the project.
Okay, thank you for that. Let me take just one more question because our time is up now. It's 6 o'clock now, and we're going to finish at 6 o'clock. The question is from Vishwanath Petkar from Paris. His question is, from your experience, does the nationality of the arbitrator affect the quantum of the award? Do US arbitrators award more in damages than UK arbitrators or French arbitrators? What do you think of, what do you make of this? Andrew? Hello? Hello? Andrew, can you hear me? Looks like we lost the connection with Andrew. Oh, okay. Oh, no, I'm so sorry. We lost that connection now. Well, I don't know if any member of the audience wants to take that question. It says, from your experience, does the nationality of the arbitrator affect the quantum of the award? Do US arbitrators award more in damages than UK arbitrators or French arbitrators? I just raise up your hand if you want to answer this question. Okay, Andrew. Andrew, you're back. Yeah, but we can't hear you. Can you unmute yourself? You're muted.
Yeah, sorry, I can't remember the question. Let me just answer the question again. What was the question again?
Okay, the question is from Vishwanath Petkar from Paris. He says, from your experience, does the nationality of the arbitrator affect the quantum of the award? Do US arbitrators award more in damages than UK arbitrators or French arbitrators?
Gosh, what a challenging question. You know, I really don't know. I really don't know. That would be very interesting for a Queen Mary study or something on that question. I think sometimes people feel that US arbitrators may be used to bigger numbers. I worked on a case with French arbitrators, and they came to a very big number. You know what? I really don't know. And obviously, and probably politically correct, it would be good, not right for me to say either. I really don't know the answer. I don't know if anybody else has a view on that one. I'm sorry, I just don't know.
Okay, thank you so much. Our time is fast spent, and it's 6:03 exactly now. So let me, on behalf of all of us, say a big thank you to Andrew for his very, very insightful and informative insights into the issue of evaluation of damages in international commercial arbitration. Like I said earlier at the beginning, this kind of conversation will come on from time to time under the auspices of the AfAA, because it's part of our mandate to make sure that we keep our members informed of goings on in the arbitration industry, particularly on very, very complex areas where you need to shed some light on. So I want to thank all of you who have found time within your busy schedule to join us from different parts of the world, and also to wish you happy vacation. It's vacation time now, so I wish you happy holidays. Thank you. Thank you very much. Bye.
Thank you very much, Chief Bayo.
Thank you. Thank you, Andrew. Bye.